Welcome to PaperLoud, where we dive deep, stay critical, and always speak out. Welcome to America, where the Constitution is sacred unless it gets in the way. Today we're not talking about a trial. We're talking about a turning point. The U.S. Supreme Court is no longer just a courtroom. It's a stage and a script written by history's most polarizing defendant. Donald Trump isn't on trial. The rule of law is, can a president be above justice if his crimes are official? Can a court stay neutral when it's stacked to one side? This isn't about Trump. It's about a system cracking under the weight of its own myths. Trump's legal firewall imagined being accused of trying to overthrow a democratic election and still having the time to sue the courts for daring to hold you accountable. Welcome to Trump versus United States, where the stakes aren't just legal, they're constitutional. At the heart of this legal circus is a deceptively simple question. Can a former president be prosecuted for crimes committed while in office, if those crimes were official duties? 6 of the 9 justices say yes, but only sometimes. Translation: if a president claims he was doing his job, the courts must presume immunity until proven otherwise. It's a legal doctrine so vague it might as well be a get-out-of-jail-free card, wrapped in the Constitution. Let's be clear, this has never happened before. No former president has ever stood before the highest court to demand immunity from criminal prosecution for attempting to overturn an election. This is not a trial. It's a precedent, a new rule book stitched together by legal interpretations and ideological loyalties. Critics have already dubbed the ruling a constitutional monarchy in disguise, where presidents can abuse power under the banner of official business. One dissenting justice warned, "The president is now a king above the law, immune if he orders the military to assassinate political rivals." Justice Sonia Sotomayor, but for Trump, this isn't about winning in court. It's about running out the clock. By appealing to the Supreme Court, he's ensured that no criminal trial will begin before the 2024 election. That's not a side effect, that's the strategy. He brands every subpoena as a witch hunt, every judge as a puppet, and every legal setback as proof of persecution. To his followers, he's not evading justice, he's fighting tyranny. And the court? It's complicit, whether by intent or inertia. He's called Supreme Court rulings dangerous, accused the justices of sabotaging his presidency, and still expects their protection. The relationship isn't legal. It's transactional. So here's the question. Can a president do anything, as long as he doesn't lose? If immunity hinges on what's official, and presidents get to define that, what can't they do? Send troops into Congress? Jail journalists? Block elections? By the time lower courts decide what official means, the ballots will already be counted. This isn't about Donald Trump. It's about a legal system bending backward for a man who weaponizes delay. The bigger issue? Whether the Supreme Court is still a courtroom or just the last firewall of a collapsing order. The court on trial for over 2 centuries, the U.S. Supreme Court was sold as the last neutral ground in American politics. 9 justices above the fray, guarding the Constitution like secular saints. But in 2025, that illusion has cracked. And no, it wasn't Trump who broke it. He just kicked down what was already rotting. The real story? A court transformed into a political weapon. Neil Gorsuch, Brett Kavanaugh, and Amy Coney Barrett, all handpicked by Trump. All confirmed under Republican Senate majorities. They weren't selected for neutrality. They were selected for loyalty to originalism, a legal philosophy that conveniently aligns with conservative politics and conveniently silences progress. Add them to Clarence Thomas and Samuel Alito, and you have a supermajority that can rewrite decades of precedent with a smirk and a footnote. This is the court that overturned Roe v. Wade, gutted voting rights protections, and expanded gun access during a national violence crisis. Each decision followed the same pattern: public opinion, ignored; legal precedent, overruled; conservative agenda, delivered. Welcome to the shadow docket court, where decisions are made in silence, without hearings, without explanations. Public trust? Collapsing. Approval of the court has dropped below 40%. Among younger voters, it's far worse. But that's not all. Ethics scandals now haunt the bench. Clarence Thomas accepted luxury gifts from conservative billionaires. Samuel Alito jetted off on donor planes while ruling on their interests. When confronted, they didn't apologize. They called it an attack on judicial independence. Congress demanded accountability. The court responded with a voluntary ethics code, vague, unenforced, and utterly meaningless. It's like asking arsonists to write fire safety regulations. Government watchdog group meanwhile, international observers are stunned. In Brussels, a senior EU commissioner reportedly called the ruling a warning signal for Western democracies. Hungary, Poland, Israel, the list of democratic backsliders is growing. America, once the model, is now being added to the watch list. So ask yourself, if the court is biased, the presidency shielded, and Congress paralyzed, who's left to hold power accountable? If the referees take sides, what happens to the game? Endgame for the rule of law. This was never just about Donald Trump. It was about testing the limits of American democracy and watching them bend. What the Supreme Court just did wasn't a ruling. It was permission, a precedent that says, if you do it while in office, it just might be legal. And if it isn't, good luck proving it in time. With vague definitions of official duties, any future president can now fire prosecutors investigating them, use agencies against rivals, challenge election results, all with immunity. This isn't democracy. This is lawful authoritarianism. The system was built on the assumption that bad actors would be stopped by strong institutions. But when those institutions rubber-stamp the abuse, the entire architecture collapses into symbolism. The 2025 election will be the next pressure test. The courts are now inside the arena. Every verdict is delayed. Every appeal favors the powerful. And every silence speaks volumes. What if the court doesn't choose? No ruling. No clarity. Just ambiguity. In that vacuum, anything goes. A president could declare victory before ballots are counted, deny results, mobilize unrest, then call it all official conduct. If the court doesn't draw the line, the people might. But lines drawn in the streets rarely end peacefully. The Constitution doesn't enforce itself. It's paper until people decide to defend it. So what happens when none of that happens? The terrifying truth? A Supreme Court that hesitates is still making a choice. By refusing to draw the line, they don't stay neutral, they surrender. And in a system built on balance, surrendering justice means tipping the scales. So here we are, one man, dozens of charges, and a court too cautious to act. One nation, one constitution, and a judiciary pretending this is business as usual. But justice delayed is not just justice denied. It's permission. Permission to repeat, escalate, and eventually normalize the unthinkable. What happens next isn't a legal matter. It's a civic one. The courts may falter, but public accountability cannot. Not in silence, not in comfort, and definitely not in 2025. Because if the rule of law becomes optional for the powerful, it disappears for everyone else. Share your thoughts in the comments and stay critical. If this topic moves you, let's discuss it together. Subscribe to PaperLoud for more engaging debates and in-depth analyses. Until next time, stay loud, stay curious, stay critical. Take care.